there, everybody. My name is Carol Easterly. I am one of the museum program coordinators here at the Kentucky Historical Society. Thank you so much for being with us this afternoon for our very first Friday of 2021. Hope you all had a great holiday. I'm glad to have you back with us. Before we get started, just a few reminders. If you'll please keep your microphones on mute throughout the program so that we avoid any background noise. Do feel free to keep your camera turned on if you would like to. It's nice to see everyone's smiling faces. And please feel free to submit your questions and your comments using the chat feature at any time throughout the program. And you can open the chat by just clicking on that conversation bubble down at the bottom of your screen. While the presenter is speaking, you may want to choose speaker view just so you will see her clearly, as well as any images that she uses in her presentation today. So let's see here. And regarding questions, we're going to save those for after the presentation, and I'll communicate them to Dr. Fredette, who it is my very good pleasure to introduce to you now. So Dr. Allison Fredette, our speaker today, is joining us from Appalachian State University in Boone, North Carolina, such a beautiful part of the world. She's been teaching there since 2014. She's originally from West Virginia, though, and earned her BA and her MA at West Virginia University, and then received her PhD from the University of Florida. And while she was working on that PhD, she was actually a research fellow here at the Kentucky Historical Society, and also with our Louisville friends at the Filson Historical Society as well. So we're especially proud to have her back with us today. Dr. Fredette's research focuses primarily on women in the American South, and she's especially interested in the ways that gendered expectations can vary by region and how they have shaped our lives and our identities. She's published numerous journal articles and presented at conferences around the country, but also in 2020, she published her first book, which is she's going to be sharing with us today, Marriage on the Border. And I will post a link in the chat for where you can get a copy of that if you haven't already. I'm sure that you will want to, as well as a link to her website so you can learn more about her other work as well. And so without further ado, Dr. Fredette, please take it away.
Thank you so much for having me today. I'm really excited to share some of my work with you all. So if you don't mind, I'm going to share my screen. All right. So as Carol mentioned, my talk today is drawn from my book, Marriage on the Border, Love, Mutuality, and Divorce in the Upper South During the Civil War. It was published last year from the University Press of Kentucky. And it really, so I know it says during the Civil War, but that's very broad. It's actually, it looks at a kind of a 40-year period, about 20 years before and after the Civil War. And it looks at white gender roles in households in this border South area. And I'll talk more about that in a minute. For the talk today, I'm going to talk a little bit about why I wrote this book and kind of the broad book's arguments. And then I'm going to really focus the bulk of my talk on one chapter. But feel free to ask me anything in the Q&A and I can talk more broadly. So like I said, first, I want to talk a little bit about why I came to this topic. A while ago at this point, I worked on this project for about 13 or 14 years. So basically, as Carol mentioned, I'm from West Virginia. And when I was getting my master's at West Virginia University, I had a friend who had gone away to med school in Chicago. And he told me about this experience that he had there where it was the first day of med school and they were, it was a bunch of med students. They're all in this big hall and they're sitting in these seats and they have a speaker come up and he basically says, when I say the region that you're from, you stand up. And so he says something like, who's from the South? And my friend starts to stand up, and then he's like, no, and he sits back down. And then he says, who's from the mid-Atlantic? And my friend kind of stands up and is like, no, I'm gonna sit down again. And he's like, who's from the Midwest? And my friend's like, yeah. And so finally the speaker calls on my friend and is like, where are you from? And why are you so confused about it? And my friend says, I'm from West Virginia. And I don't know which of those it fits into. He said, it's Appalachia, but you're not going to say Appalachia. And so that story really stayed with me and struck me as a West Virginian, because I really wanted to explore why we're so confused about where we're from, why we feel like why we fit in multiple categories and yet none of these categories. So that really led me to this concept, this place, which is the border South, in the mid-19th century. And again, many of you may have seen talks about Appalachia. Appalachia is a region, as a kind of conceived, created region, doesn't come about until the late 19th century. So people who lived in this region at this point didn't think of themselves as Appalachians. And so I really wanted to look at how they viewed themselves then. And I really started to see them as these border residents. And this is a border South region. So this is a picture of the United States in 1860, which is kind of a center point that I'm looking at. So as we all know, the Civil War began in 1861. And so often when you hear people talking about the border in the Civil War era, it's meant very literally as the border between North and South, or Union and Confederate. And border states are conceived as those states that had slaves but did not officially secede. And I really wanted to think of it much broader than that. So the definition that I conceived of for the border South, I really thought of it as a geographic border, but also a cultural and a social border. I thought of it as Northern and Southern as well as East and West. So Kentucky, for instance, which is one of the places I study, was often kind of the gateway to the West. If we remember how the West used to be, I saw this as a crossroads region, places where people were constantly moving through and bringing new ideas and fusing those together. So I really liked thinking of that. I also saw the way border South residents wrote about themselves, and they saw themselves as different. They would say, we're not like people up north or down south. They really saw themselves as this in-between group. So various scholars have defined the border, the middle border, the border South, as having different states, anywhere from Missouri to Delaware, including states, down, in the southern section, including Missouri, Tennessee, Kentucky, and West Virginia, but also into the southern parts of Illinois, Indiana, and Ohio. For my purposes, my book focuses on Kentucky and Western or West Virginia. West Virginia becomes a state in 1863. So it'll be a little bit confusing because sometimes I call it West Virginia, even though it was Western Virginia, but that's the region I'm looking at. And I contrast them with Virginia, or what I sometimes as a West Virginian call Eastern Virginia. And so I really wanted to understand how these places were unique and different. So the book's argument has a few components. First of all, like I said, after I kind of conceived of that kind of cultural, social, geographic border, I really looked at the way that border created this really rich ground for adaptability and fusion of ideas, and specifically ideas of how to be a man or a woman, that they are a little bit more flexible in their understanding of gender roles in the household than you're going to see other Southern households being. Specifically, I looked at two ideas, mutuality and contractualism. So mutuality, by that, I mean, it's different from equality, right? So many of us, when we think in the 20th and 21st century of gender roles in the household, we think with this lens or this frame of equality. But when I was looking at it, this isn't the language that Kentuckians and West Virginians were using. Instead, they talked a lot about mutuality, by which they meant men and women in the household having compatible or complementary roles, both of which were important and vital and valued. They saw men and women as individuals with real strengths, and to bring into this relationship and working together, these mutual roles in making a household economically successful, or just, a loving and supportive relationship. Contractualism is thinking about marriage as a contract. So rather than a purely religious institution that can never be dissolved, how much did people think of it as marriage as a contract that had terms, by which you agreed to go into that contract, and by which, if you broke them, you could leave that contract? So I saw both of these happening in greater amounts in the border South, in Kentucky and West Virginia, than in other parts of the South. And with that, I saw higher rates of divorce, for instance. I should say here, I'm a few minutes in, so I apologize for not giving you a warning before now. When I was asked to do this, I know that Carol kind of mentioned it's close to Valentine's Day. So I will warn you that I'm going to talk about divorce mostly. So ironically, sorry, a lot of my work is on divorce. But I think divorce is a really interesting way to look at people's understandings of how to be a husband and wife. So I'm going to talk about that. But you can ask me about the love part of my book title in the Q&A if you want. I still see these as places that have a very strict racial hierarchy. These are, of course, slaveholding states, Kentucky and West Virginia. And the households themselves, whether they have enslaved people living in them or not, are very much ensconced in that society with slaves. And they have an understanding of racism and race as a hierarchy. But unlike other Southern places, they seem to separate out their understanding of gender roles and racial roles. Whereas other Southern states really see those two things as tied, and any threat to slavery or to race relations basically is a threat to the relationships between men and women and parents and children as well. Whereas I saw in the border South, there was a little bit more of an ability to, unfortunately, still carry very racist views, but also have somewhat progressive views toward gender. Sorry, I can't actually see what that says. Oh, and the sources for the book, I looked at a lot of manuscript sources. This is what the Kentucky Historical Society was wonderful for. I read diaries. I read letters from husbands and wives. I read prescriptive literature, which is advice manuals that people would give people on their wedding day, brides and grooms, that literally would say, here's how you should be a husband or a wife. So I looked at speeches, essays that women would write at female academies. And then, of course, I used legal documents. I used divorce records from the state level all the way down through the local level. And I really focused with the local records on 6 counties in these. I'm going to go quickly through these. If you want to know more about how I chose them or about the counties, I can explain it in Q&A. But I looked in Kentucky at Franklin County, which is where the Kentucky Historical Society is, in Frankfort. It's also in the bluegrass section of the state in the 19th century, which is the part of the state with the highest percentage of slaves. I looked at Warren County with its seat of Bowling Green, which is which was the Confederate headquarters during the Civil War. So I really wanted to kind of I was trying to find 6 counties that gave me all different perspectives on this region. Confederate sympathizing, Union sympathizing, counties with a large slave population, counties with very little. So for example, in Western or West Virginia, I used Ohio County in the Northern Panhandle right along the Ohio River, where Wheeling is, which is very industrial, very few slaves in this county, a lot of immigration. So a very different picture of the border South. Maybe a lot more like a small version of some of the cities and towns along the Ohio River in Kentucky as well. And then for reasons I can explain in Q&A, I couldn't find any other county records in West Virginia. So I used Tazewell County in Western true Western Virginia, in Appalachian Virginia, to get a feel for that kind of more deeply Appalachian part of West Virginia. And then I used Fauquier County, which is in the northern part of Virginia, which was one of the, outside of Appalachian Virginia, is one of the counties in Virginia with maybe fewer slaves. And by that, I still mean 50% of the population was enslaved. But it's fewer than Amelia County, my final county, which 70% of the population of that county was enslaved before the Civil War. So that's really deep in the kind of heart of plantation Southern life. So like I said, the bulk of the talk today is going to be from my second chapter, which looks at the experience of divorce in Kentucky, Western Virginia, and Virginia in the 10 years before the Civil War. So I'm going to start out with a story. In 1837, after 3 months of marriage, Mahala Carroll left her shocked husband Simeon and her Franklin County, Kentucky home and refused to return. In response to Simeon's letters, she wrote, "You need never to make any calculations of my living with you again. I never intend to, as long as I draw the breath of life." Seeing no other option, in April 1842, Simeon Carroll filed a petition in the Franklin County Circuit Court asking for a decree of divorce and all general relief. Responding to his petition, Mahala admitted she had voluntarily abandoned her marital home. She did not explain to the court her reasons for leaving, but stated that they, quote, were sufficient in her judgment to take the steps which she has done. She also told Simeon that she joined in his desire for a divorce. Quote, "I grant you the privilege of so doing," she assured him. "I never have objected to it from the beginning." Within a month, the court granted Simeon's petition and separated the estranged couple forever. So I'll explain more in a little while why this is especially an unusual case. But I really think this case is not unusual for Kentucky, but it is unusual for the South during this period. The South in this period has often been defined as literally, quote, a harsh legal culture. That's one historian of divorce in the South has called it that. Southerners especially were resistant to divorce. They saw slavery and these other household relationships as really intertwined. And they basically said, if wives can divorce their husbands, how, is the next step is slaves being able to be free and leave their masters. So they saw those two things as kind of mutual. And if one of those kind of fell, then the other would potentially fall as well. After the Civil War, you literally see the Virginia Supreme Court using the language of social pillars and saying the emancipation that social pillar has fallen, we have to maintain this pillar of marriage. But in this, you don't see any of these fears. You see actually a pretty simple, straightforward divorce that is talking about both people wanting a divorce and the court saying, okay, sure, you can have a divorce. So while other Southerners were resisting divorce reform, border South courts are showing that they are more flexible and they're accepting of the ability of people to choose to end their relationships for a whole variety of reasons. So my argument has three parts depending on which place you're looking at. And for reasons I'll explain in a minute. So Kentucky, I really saw in Kentucky, there was a strong desire in these records for mutual separation. And by that, I mean this decision that both people want this marriage to end, and allowing easier access to divorce. And in Kentucky, what's interesting is I see it both at a legal level in terms of state statutes and the courts and in the people themselves. Whereas when I moved to Western and Appalachian Virginia, which are operating under Virginia state law created out of Richmond, the law is more restrictive because it's being written by those more conservative Eastern Virginians. But these Western Virginians, these border Southerners, they actually their attitudes are more like Kentuckians, but they can't behave like Kentuckians because they don't have the same law as Kentuckians. So they are manipulating the law in different ways to get what Kentuckians do, basically easier access to divorce, but they have to do it differently. Whereas in Eastern Virginia, in the counties I see there, I see more of the kind of traditional Southern type of divorce, which is a lot of this use of emotional language, of having to prove, these tell these stories of woe of why a divorce is necessary. So for the next part, I'm going to look at the variations in state laws between Kentucky and Virginia during this period. I really think state law can tell us a lot about the kind of elite perspective on marriage and divorce. But it's also interesting to see the way that average Kentuckians and West Virginians are using those laws. And then I'm going to talk about the idea of collusion, which I'll define in a minute, and mutual separation before talking about where you see this emotional language and where you don't in these records. So Kentucky law was surprisingly progressive for this period. And I should add the caveat, of course, when I'm talking about being progressive, it isn't progressive by our means. And also when I talk about there being easier access to divorce, very few people are still getting divorced, but it's a comparison issue compared to other places. You're going to see much more access here. So during the 19th century, divorce law was divided into kind of two blocks. You could either file for what was known as an absolute divorce or a divorce from bed and board. An absolute divorce is how we would think about divorce today. Basically, you go into court, you say, I don't want to be married to this person anymore. The court divorces you, you're financially disentangled. If you're a woman, you could potentially change your name back if you petition for that. You can remarry. So you're just totally severed from one another. A divorce from bed and board gives a formerly married woman the right to own property. So she becomes femme sole. So she becomes legally independent from her husband. She can own property, she could keep her own wages, but neither person can remarry. So there's still a little bit of a connection there. And in most places, this divorce from bed and board is the preferred option. The courts are saying, I understand that women might need some protection. If they have a husband who has behaved badly, they need financial independence. But we don't necessarily want to encourage people to just divorce and remarry and divorce and remarry. But you actually see the opposite in Kentucky. In Kentucky, the vast majority of reasons to get a divorce fall under this category of absolute divorce. So in Kentucky, you could get an absolute divorce if your spouse was imprisoned and they didn't put a length of time, just any imprisonment, you could get a divorce. If your spouse had concealed a loathsome disease, so by this they meant a sexually transmitted disease. If the marriage itself was conceived by force or fraud, I don't see a lot of force cases. That would be if a person forced you to marry them or a parent forced you to marry someone. So in the United States, a parent can't force you, even during this period, to marry someone against your wishes. Fraud is usually a case of a man saying that a woman was pregnant at the time of the marriage, but she didn't tell him. Impotency, so when basically the marriage can't be consummated on either party's end, you can have an absolute divorce. Adultery, abandonment of only 1 year, which is a pretty short period in divorce law in this era. And then the one that's really interesting to me is the separation of 5 years. That is basically saying if both a husband and a wife agree that they don't want to be married, they can move apart and live apart for 5 years, and then they can get a divorce. All of these other ones imply that someone has been at fault, right? This is a period of fault-based divorce where someone has to do something wrong and the other person has to be innocent. We're before really no fault divorce, which is the divorce system we currently live under. But this separation is a no fault. It's a gesture toward no fault. It's saying, basically no one has to have done anything wrong. You could just decide you don't want to be together anymore. You don't love each other anymore, and you can separate. And in 5 years, you can have a divorce. You could also have a divorce. These are going to be, if you're a woman, you could file if your husband has been a confirmed drunkard or has wasted the estate. So basically neglected you. Neglect comes up a lot. Or cruelty, which can be used for either partner. I have seen ones of husbands charging wives with cruelty, but it's much more likely to be the other way around. So those are all for absolute divorce. Whereas divorce from bed and board, the Kentucky law basically says anything else you want to give us, we'll consider it. So they've really put all their eggs in that absolute divorce basket. Whereas in the same time period, if you look at Virginia law, their reasons for absolute divorce are adultery, impotency, imprisonment of 7 or more years. So someone has to have committed a fairly serious crime. And that's it. That's all you can do for absolute divorce in Virginia. Whereas a lot of these other charges, cruelty, abandonment, they will fall into divorce from bed and board. And in Virginia, you have to have been abandoned for 5 years, and that you still can't get the absolute divorce for abandonment of 5 years. And so you're definitely going to see, because of the way the state's law shapes, the people's courtroom experiences, people are going to craft their divorce cases to these laws. I think the thing that's complicated about studying divorce law, and I talk about this a lot with my students, is when you're studying divorce cases, they are great sources for reading kind of a duality, because yes, certainly there's some level of truth in a divorce case, but there's also a lot of lies. There's also people obviously trying to make themselves look better, making their partner look worse, but there's also the fact that in this time period, people know there's only a set number of reasons that a court will divorce me, so I have to tell them what they want to hear. And so I have to fit myself to this. Everyone I look at uses a lawyer. So people go to a lawyer, and the lawyer presumably is the person who tells them, okay, well, here's the things we got to check off the list. So you see that when these court cases come in. So I basically, in my research, I looked at those divorce cases or those divorce laws. And then I started looking at, okay, how many people are filing? What are they filing for? What charges are they using? Tried to kind of work backwards from that. And you can see here that in this 10-year period before the Civil War, that most Kentuckians filed for absolute divorce, which makes sense. When we saw the state law, that's where the state law was directing them. It was saying the usual reasons you want a divorce, those will get you an absolute divorce. Unlike, for example, Fauquier County in Virginia, where people are saying, well, I know that most of my charges are going to fall in the category of divorce from bed and board. Meanwhile, though, even though they're under Virginia law, Ohio County and Tazewell, Western and Appalachian Virginia, they are filing for a really high number of absolute divorces, despite the fact that there's very few reasons that they can do so. And so I think I looked at that and I was like, I saw them moving more toward Franklin and Warren County. They were behaving like these Kentuckians were. They wanted that kind of flexibility that Kentuckians had. Amelia County, yes, it has 100%, but it only has 2 cases, and they are very unusual cases. I'll talk about one in a minute, and you can ask me about the other one if you want in the Q&A. But they are certainly not typical. The other thing about Amelia County is, basically when I found Amelia County in Virginia, I had a list of counties in Virginia by what percentage of their population was enslaved. And so I wanted to look at a really high density plantation area. And the first 3 counties I found before Amelia County had no divorces in this period. Amelia County was the first place with divorces on that list, and it only had 2. So that was, it's definitely the case that in Amelia County, divorce was frowned upon and infrequent. So once they filed the divorces, how successful were people? Kentuckians actually were not the most successful. They were more successful than not. They were more successful than people usually were during this period. So you have over 50%, over half of the divorces being granted to the Kentuckians who filed. And they have by far the most people filing. So they have the largest number, despite the fact that the populations are fairly equivalent in these places. But Ohio County and Tazewell County have these really high success rates. So people are using serious charges, but they're also getting those. The court is willing to accept, okay, you want a divorce, absolute divorce? Sure, let's do it. Let's make sure you're not married anymore. So then I broke it down by what charges they used. So what were they actually charging their partner with? And in Franklin and Warren County on the right, these Kentucky counties, you can see that they have a variety of reasons that they are charging. And they use things like intemperance and cruelty much more often than you see in Virginian counties, Western or Eastern. Um, and I think one of the things that I really thought about is I don't think I really there's not enough different about these places that I would expect, for instance, to see more levels of domestic violence in Kentucky than I would in Eastern Virginia. In fact, if I had to predict one, I would predict more domestic violence in Eastern Virginia, just based on the fact that there's often a connection between violence, for types of violence in the household, slavery, areas with intense levels of slavery, violence begets violence. But I think it's the fact that, so these places should look fairly similar, or at least shouldn't look the way they do here. So that basically the state law is driving some of this breakdown in Kentucky. Whereas in Ohio County and Tazewell especially, people were using the charge of adultery a lot, which again makes sense if you think purely, well, that's what the law is. They know that if they look at the law, they have very few reasons to get a divorce. Imprisonment, you have to have a record that shows that the person was in prison for 7 or more years. You can't make that up. And quite frankly, impotence often requires a medical examination. So they actually will force someone to prove that their partner was impotent. So adultery is one that is going to basically be the default. So I basically had to sit there and say, okay, well, like, is Tazewell County, for instance, like just full of cheaters, or is there something else going on here? And so I really started to think about, okay, I think they're actually using this law. They're manipulating it. They're saying, okay, well, if that's all you've given me, then that's what I'm going to use. Whereas Franklin and Warren County, they don't have to do that because the law has already given them some access there. So when I was talking about collusion, so I've already explained a little bit, but to reiterate, in the 19th century, you have a fault-based divorce system. And by that, I mean, the courts really want to see that one person is to blame for a marriage ending and one person is innocent. So in fact, they don't want to see that you're both to blame. Hendrik Hartog, who's a historian of marriage and divorce, he actually says, if a husband and wife agreed to divorce because they as private individuals wanted to divorce, their agreement is enough for the court to say, no, you can't have a divorce. Basically, the court's idea is if you've agreed or if you both did something wrong, you deserve each other. And if you've agreed, then you've colluded to get this divorce, and collusion isn't allowed. So we can't have you colluding. So they don't want to see that you're both at fault, and they don't want to see that you've agreed. But in Kentucky cases, especially, you're seeing both of those things. You're seeing people saying, well, we both made mistakes, so, let's separate. Or you're seeing people say, like we did in that initial case that I read to you, the Mahalik and Simeon Carroll, she wrote to Simeon, and he presented to the court a letter that said, I want a divorce too. I've never objected to it. Go ahead, get a divorce. I'd like that, please. And the court's like, okay, well, you can have a divorce. In most places, a letter like that would have been enough to get the case thrown out. The court would not allow a divorce for that reason. But in Kentucky, they're allowing collusion and they're allowing mutual separation, that 5 years. If you just want to, separate, that's good enough for me. And we can see this in another case I found of the McKees, George and Susan. George filed for divorce in Franklin County again in 1856. And he wrote that the couple had lived together for some years. He's not specific. They lived together a little while. And then he says they separated and have been living separate and apart for 5 consecutive years. And so I think you see someone actually using this separation clause in the law. But what's especially interesting to me about George McKee is George McKee was a judge himself. And he was a member of the Kentucky legislature at the time that they were debating divorce laws and changes and things like that. So he's the person who's very familiar with the law, and he knows how to use it, and he knows this is going to be acceptable to the legal community because he's a member of it. So I think we can really tell a lot about both people on the ground, but also how the legal system in Kentucky viewed this law by looking at his case. His wife did write back. She did respond, and she said, that yes, they'd separated and lived apart. She wanted to state that like it wasn't her fault. She said it's occasioned by no misconduct on her part. And she said she'd been a good wife, she'd been faithful, but she never actually blamed her husband. So I think you see, this is still the 19th century. She's still worried that she's the wife, she's gonna get blamed. But she doesn't actually turn it around and say, well, you know what he did. She's fully willing to say, no one is truly at fault here. I'm not at fault. He's not at fault either. And the court accepts that, and they are divorced. Meanwhile, in Ohio County, where Wheeling is, you see another case here that I think kind of shows that manipulation. Christina and Levi Wells, she filed for divorce in 1857 and said that he had committed adultery. He did not object, so he didn't file any response. But she did submit a letter into the court record that he'd written to his mistress, Annie, which is pretty good proof that he is having an affair. But in that letter, he wrote to her, I love you, I will be with you soon. And he literally wrote, quote, I will have a divorce soon. So you can see that he's aware of the divorce case and he is hoping that it happens. And the court is reading this. They know that she wants a divorce. She's filing for it. He wants a divorce, and they're willing to allow it. I think the other thing, I'll talk about this in a second, is looking at when people respond to the cases. So another case in Appalachian, Virginia, in 1859, Leah Charles wrote to the court, and she basically said her husband, George, had divorced her in 1853, so about 6 years before. And she said he had become, quote, dissatisfied with the marriage. But she wrote, dissatisfaction isn't reason enough to get a divorce in Virginia. So instead, he received one by intrigue and corruption, are her words. If we look back at that actual case in 1853, George had charged her with abandonment and adultery. And what we can see is that a subpoena was issued to Leah at the time in 1853. She signed it and accepted it, and then she never objected to the charges. So she's saying 6 years later it was intrigue and corruption, but at the time she seems perfectly willing to go along with it. If we dig a little deeper about why she's actually writing the letter in 1859, we discover it's that George and Leah want to get remarried. And because she had been divorced in 1853 under Virginia law, and she was accused of committing adultery, Virginia law said if you were the one that committed adultery, you couldn't remarry at that point. So she was basically saying, can I remarry? And she actually wanted to remarry the guy who had divorced her in the first place. I guess that is a love story because they did stay married after that. Her husband died 4 years later as he was a prisoner of war in the Civil War. So that is sad, but they did remain married for the rest of his life, at least. So like I said, I looked at this and I thought, okay, well, so a lot of people in Ohio County and Tazewell County are talking about charging their partners with being adulterous. But what we also find is most of those people aren't actually responding. So they're getting these, they know they're being accused of adultery, and they're kind of, they're like, yeah, I guess that's true. Or maybe they know, which we've seen as historians, if no one objects to a divorce, it's much more likely to happen. Whereas a divorce that someone objects to, that becomes more complicated. And you see, for instance, higher rates of responses in the Virginia counties. The interesting thing about the Franklin response rates, because you do see more there, is most of those responses are what are called cross petitions, which basically means someone can either file a petition and say, I disagree with what that person said in their first petition. Like, that person said I committed adultery, but really they abandoned me. But in Franklin County, most of those cross petitions are actually people saying, kind of like Susan's, yeah, I agree, we should get divorced. I'm just going to second this. And so the courts are allowing those cross petitions there. So the last thing is talking about this emotional language. So again, when I'm talking about emotional language, I'm using a historian named David Silkenat. I'm using his terms. He studied divorce in North Carolina. And he argued that in North Carolina, he saw a shift from this emotional language to a legalistic language after the Civil War. So he basically argued that before the Civil War, the divorce cases were basically these long, detailed narratives talking about, usually the person filing was saying, I did this right and that right, and this is the 7 different things that this person did wrong, and I really tried to put up with it, and I wouldn't be here if I didn't absolutely have to file for a divorce. I know I shouldn't, but I really need it. Whereas the legalistic language is more like, the law says I can get a divorce for X, so I'd like one, please. And so he sees that shift happening with the Civil War. Whereas what I think is interesting is this has already happened, I've found, in the border South. Kentuckians especially are already doing that. They are already perfectly fine to say, the law says this, so give me this. Whereas especially Eastern Virginians, they're crafting these huge narratives. So for example, the Baylesses, in 1851, Martha Bayles charged her husband with conspiring to defraud her of her property, rough behavior, failing to support her. She basically said she had she still wanted to be married. She was like, if he would ask me, if he would come back, I would still be married to him, but he won't live with me. He's refusing to live with me. She said that basically at the beginning of their marriage, he had left Virginia, he'd moved to Tennessee, and he lived there for 7 years and had not written to her, not sent her any money. He came back and she basically said, will you take me back? And she was like, of course, I will take you back. She tells the court, I'm willing to be a wife. And so basically he stays for about a month and then he leaves again. And this goes back and forth for 25 years. He comes in, basically lives with her for like a very brief time and then goes back. And so she basically says, well, after 25 years of this, I realized I'm destitute. I need a divorce. And she's not successful. So she builds this whole narrative and she still can't get the divorce. Elizabeth Jackson had been married for 30 years at the time she sued her husband, John, for divorce. And she basically said her husband had been cruel. He was drinking. He was not working. He had neglected her. And she said, quote, I determined to bear up under it long and patiently. But even there is a point where forbearance, even in a wife, ceases to be a virtue. And she says that happened when she discovered he was having an affair. And so she files for divorce at that point. And then the Wingos in Amelia County, her case, she basically says, I wouldn't have done this, but he has committed what she kind of describes as she doesn't say the ultimate sin, but she goes around it. Basically what comes out is her husband, John, has fathered a child with a free Black woman in the neighborhood. Not only that, but he has moved out and he's living with this woman and has recognized her as as his wife. So not only is he in an interracial relationship, which we obviously know would be a huge sin in Virginia during this period, but he has recognized and elevated this woman of color to his wife's level. So that is one of the 2 cases in Amelia County. Whereas in Kentucky, the 2 cases, I'll use an example. In 1861, America Palsgrove filed for divorce from her husband. She basically checks off, she says the date of her marriage, which was only a year and a half earlier. She got married in Henry County, Kentucky, and then she now lived in Franklin County. She had lived in Kentucky for 5 years, and she said her husband had abandoned her for more than a year before the suit, and that the cause had occurred within the state. She called 2 deponents who basically said, yes, her husband has abandoned her. Within a month, she had her divorce. Similarly, the Hewletts, 1860 it's only a few lines long, with Nancy basically saying she had married her husband in 1835 and that she lived with him until 1855 and that he had deserted his wife at that point. She only has one deponent, which is interesting because the law technically required two, but they still allowed her to have a divorce. So in conclusion, I think you can really see the ways in which Kentuckians especially are accepting collusion, they're accepting agreement. They are on this path more quickly than other Southerners toward a divorce system we might see today. Western Virginians want to be where they are. They're not yet. One of the things I talk about in my book is that they get there by the end of the war. So I think that these are really interesting states that are very different than I often think we conceive them, by the kind of understanding we have of Kentucky and West Virginia. They are more progressive and more complicated than we may know them even to be. So thank you all. I have no idea what time it is, so I hope I didn't talk too long.
Oh, no, you're good. Thank you, Dr. Fredette. That's really, really interesting. And I'm glad that you kind of address those divorce laws. I definitely have some questions, but we've had a couple that were submitted in the chat. We're at about 12:46. I know we've got
Sorry.
you. Let's see. So Jack would like to know, did you have to be a certain age to marry in Kentucky? Was there a...
Yes, so you did have to be a certain age, but it was quite young. Off the top of my head, I think it was 12.
Okay.
Yes.
I think that's right too. I think that was one of the women's issues that was really, and later in the century, that they wanted to raise the,
yes, that comes about, in that kind of late 19th century, early 20th, the kind of progressive era. They want to end, raise the kind of age of consent.
I think, to like 16 or something.
Yeah,
it's still
very
young.
Some I think is too low, but yeah.
Right. But yes, they wanted it raised above 12. So, and Rogers also asked, what was the procedure for divorce laws or for divorce before 1852? Because if they were written, what was, if I think you mentioned laws that were written in 1852. So was there a system before that?
So that's a great question. Yeah. So there were other laws that were written before that. Most, at the time of the American Revolution, most states have divorce laws of some kind. And in the 19th century, at this point, every state allows for divorce except for South Carolina. But before 1850, actually, you had to file in the legislature to get a divorce. So you actually would have to basically write to the legislature, to your representative, and you would lay out a petition similarly that you would in a court, but you'd have to do it before the legislature. And then they would actually have to pass a bill saying that so you can actually look in, the statutes and read through, and they'll have a bill to like build a road and then a bill to divorce someone. It was a lot less frequent that way. And by the 1850s, most states in the country, Virginia did it around the same time, had decided maybe it's better if we just have local courts handle this instead of spending our time as, a state body trying to figure out, an average person's divorce.
Wow. Well, thank you. I've seen some of those statutes, just looking at, for research, and I wondered about that. Like, my God, did you really need legislation, to get out of it?
Well, I guess I should say you didn't, because I also will say a lot of people just ran off from other people. Okay. So to legally end it, you would.
Yes.
But to technically end it, no.
And that changed in 1852. Okay, good to know. Jessica would like to know, how do socioeconomic levels play into the divorce dynamics?
So what I thought was really interesting in a lot of these cases is that you really do get a wide range of people pursuing divorce. I don't think you're going to capture everyone, and that's where I said that kind of informal divorce system does still apply, where people who are truly impoverished are not as likely to go into the court. They're more likely to just move apart from one another. But you do really see people who are kind of working class in these divorce records. In my estimation, you're actually less likely to find elites than working class. I almost think that there's more of a stigma in the elite classes against divorce, and the people who are really trying to, if I see that tale of woe in Kentucky or Western Virginia, they tend to be more elite people. And their cases go longer. And I think that also has to do with their financial resources. They tend to have more deponents. You have to pay for each of the deponent, each person that comes in and testifies, you have to pay. You know, I have a cruelty case from the post-Civil War period in Wheeling that goes on and on and on, and it's a kind of a wealthy couple. So I think they tend to be longer, but actually the most of the people I see are working class. And the last thing I'll say about that, I guess, is that I think one of the things that's interesting about that is that especially in Frankfort and Bowling Green and Wheeling, the fact that these people are working class, they tend to live in closer quarters to one another. They know more about each other's lives. They share houses, like people are boarding with other people. Sometimes when someone is abandoned, they have to move into a boarding house. So you also have more information in a way about their lives because of how closely connected they are by their living circumstances.
Todd asked, what were the top two or three issues for divorce in Kentucky during this period?
So like what were the most common things that people filed for, I assume? Abandonment is by and large the biggest charge that Kentuckians use. And I think especially because what's interesting about the abandonment charges is they're a mix. I'd say they're kind of an even split of people who are just abandoning people and moving locally, and then people who are abandoning people and moving to like Texas. So I think the fact that, again, in the 1850s, Kentucky is kind of on this precipice of this Western frontier. You also do see a lot of people who are kind of taking advantage of just like heading out west and ditching their partner. But adultery, abandonment, and then intemperance or drinking, and then cruelty are the biggest ones. I will say one thing that's unusual I didn't include here that Kentucky has, but I've never seen anyone actually using it, is Kentucky allows you to divorce your partner if they become a shaker, but no one used that I saw. So that's in there. It's in the mix, but no one's used it.
Wow. So Bill, he says, I saw a legal record from 1865 that states, quote, in the event of divorce, that his property near Louisville was to be sold by a friend to provide for his wife and her son in Western Kentucky. He says, we haven't found a divorce record in Kentucky records. And do you have any suggestions where to look? Because she married, in quotes, married someone else 15 years later, and there's no mention of her son or first marriage in her obituary.
So not knowing where you've checked, I will say if you're doing a lot of research online and in places like Ancestry, they don't have the divorce records and things like that in there. The best place to get divorce records is going to be the state archives. Like in Kentucky, you're really lucky because all the county courthouses have sent them all to the central archive. And so the Kentucky State Archives is where I've basically located all of mine. I don't know that they're digitizing them at this point. I will say Virginia has digitized theirs, and that's Eastern Virginia. But Kentucky's doing way better than West Virginia because West Virginia has burned most of theirs, which is why I couldn't find them. County courthouses in West Virginia, to save money during the Depression, started destroying local records. So there's a real record problem in West Virginia. But yeah, I would say to look into the state archives and see if they have a record, if you know the names of the person in like a time period. And then the problem is you would have to kind of know a county, but you could maybe, if you had a handful of counties you wanted to look in, but it's hard. Finding one person is really, it's a needle in a haystack kind of a thing.
Thank you. Deborah asks, do you have an idea of when the next big change in divorce laws might have been for Kentucky. More specifically, would these laws also have been on the books during the Civil War as well?
Yeah, so so my research goes up until basically the end of the Reconstruction period, late 1870s, 1880. And the law did not change other than minor tweaks in that entire period. So again, that's something that's really interesting, is that West Virginia does, because they have to write it since they become a state. And Virginia's changes a tiny bit. In some places in other parts of the South, you see Reconstruction governments coming in, and one of the things they do is write new divorce laws to basically modernize them. And then you see those being pulled back when Redeemers come in at the end of Reconstruction. But Kentucky, it's more of a through line, I think, because they're already past where those Southern governments are, and they don't have the same period of that same experience of Reconstruction. It stays constant.
Thank you. Oh, Rogers has another research question about the divorce records. They're in deeds for the most part, and no evidence of going to the legislature, all of these before the 1850s. And they said, do you want me to send them to you? So I'll see if we can get that figured out.
I will always take things.
Yes, absolutely. All right. Well, guys, thank you. We've got to wrap things up. Please, again, check out the University Press of Kentucky website, get a copy of Dr. Fredette's book. I do hope you'll join us for some of our upcoming events. We have a trivia night on the 18th, Love Affairs and Scandals edition. And we also will have our next First Friday in March. Dr. Charlene Fletcher will be joining us and talking about race and incarceration in Gilded Age Kentucky. So that should be really interesting as well. But guys, thank you again. Have a great afternoon, and we'll see you again soon.
Thank you so much.
Thank you so much. Have a great meeting. I will follow up with an email address for that guest so that you guys.
That would be great. That would be great.
Thank you so much. Do you mind if I share their email with your email with?
Not at all. No.
Okay. Sounds good. Bye, guys.